This is Michael Swain, Executive Director of Freedom of Religion South Africa, with the news that the Johannesburg High Court has dismissed 4SA's case against the Cogta minister. Now, in our case, which was supported by religious leaders and organisations representing 11 million people from a broad cross-spectrum of the faith community, we argued that the Cogta minister's regulations imposing a total nationwide ban on religious gatherings in December 2020 and January 2021, while other similar gatherings were allowed to continue, was both unlawful and unconstitutional. Disappointingly, in a relatively brief 25-page judgment handed down on the 13th of December, Judge Valley found that since the ban on religious gatherings was no longer in place, the matter was moot or academic. He therefore found it was not in the interests of justice to decide the issues before the court. However, despite this initial finding that the issue was moot, the judge then went further, and he found that the COVID-19 regulations were not subject to the review of the court in terms of the Promotion of Administrative Justice Act, PAJA, because they were in the nature of executive policy. This means that there was no obligation on the Cogta minister to give reasons for her decision to ban religious gatherings or indeed to consult with affected parties. In addition, the court refused to declare religious workers as an essential services category in terms of the regulations, since in their view it was not clear who would qualify as a religious worker. 4SA contends that the finding by the judge goes against extensive international precedent, where the highest courts in countries around the world have found that the matter cannot be moot because the same threat remains that government may impose the very same regulations while the COVID-19 pandemic or its variants continue. Even our South African courts, including the Supreme Court of Appeal and Bloemfontein, have made similar findings in other cases involving regulations. However, more concerningly was the court's refusal to scrutinise government's actions because they constituted executive rather than administrative action. This finding has massive implications, not just for the religious community, but for the people of South Africa in the broadest sense. The Disaster Management Act already excludes Parliament's oversight over the actions of the executive. This judgment now means that not even our courts can oversee such actions. It effectively puts unfettered powers in the hands of government to make unilateral regulatory decisions regarding any and every aspect of people's lives. From a freedom of religion perspective, this judgment sends a message to millions of believers in South Africa that their faith can literally be reduced to praying at home as a result of an executive decision for which no justification need to be made and which effectively cannot be challenged. 4SA is therefore in the process of preparing an application for leave to appeal this judgment to the SCA in Bloemfontein because the effect of the court's decisions harkens back to the pre-constitutional era where immense power was concentrated in the hands of the unaccountable few. We believe that it is literally our patriotic duty to make this appeal because this dangerous precedent is too important to leave unchallenged. Please like and share this video far and wide, and visit our 4sa.org.za website or on Facebook at Freedom of Religion SA for the latest updates. Remember to sign up for our newsletter and please partner with us financially in the fight for faith and freedom by clicking the donate button. Thank you.